Well, first of all, thank you all for being here today. My name is Patrick Hughes. I'm the co-founder and president of the Liberty Justice Center. The Liberty Justice Center is a public interest constitutional law firm that was founded in 2011 to fight on behalf of individuals' constitutional rights and against political privilege and governmental overreach. The Liberty Justice Center is most known, I'm sure many of you know about us, from the Janus versus AFSCME case. We were co-counsel in that case with the National Right to Work Legal Defense Foundation, and of course the Supreme Court ruled in favor of our client, Mark Janus, who's here with us today, in that case. And in that case, the court determined that it is unconstitutional to make someone pay a fee to a public sector union in order to keep their job in government. And today, we're here to tell everyone that the Janus case, as impactful as it was, as important as it was for protecting workers' rights and the constitutional rights to free speech and free association that every American has, is that it is just the beginning in fighting for rights on behalf of workers. This morning we filed, along with the National Right to Work Legal Defense Foundation, we are, for lack of a better term, putting the band back together, filed a lawsuit on behalf of 9 plaintiffs to certify a class of plaintiffs led by Blake Leach, who is one of our plaintiffs and is with us here today, to collect agency dues. Those have stopped being collected as of the time of Janus, but to collect agency dues that were collected unconstitutionally prior to the time of the decision. And so we filed that case today to certify a class of a little over 2,700 former agency fee payers, and are looking to have the money returned to them that was taken illegally from the unions in the time prior to the Janus ruling. With that, I'd like to introduce Blake Leach. Blake is a former worker at Veterans Affairs here in Illinois. He is also an Iraq War veteran and the recipient of the Purple Heart. Blake?
Thank you, Pat. Thank you for the Liberty Justice Center and National Right to Work for helping us bring this fight. I worked at the Illinois Department of Veterans Affairs for 5 years as a veteran service officer, helping veterans navigate the VA programs. And in that time, I had over $2,500 of my money go to the union for the fair shares. And that's why I'm here today, is to continue that fight, as Pat said. I'm here because 20 years ago, I made an oath. I made an oath to defend and protect the Constitution of the United States. That oath didn't end when my military service ended. That oath continues, and it will continue until I stop breathing. And that oath is also here fighting for those 15 men that I fought next to and perished on the battlefield in Iraq. And with that, I'd like to again thank the Liberty Justice Center and National Right to Work for helping us with that fight and helping us protect the Constitution that myself and fellow men and women of this country have fought to protect. LEITCH.
Thank you, Blake. Also with us today is Mark Janus. Mark, as I'm sure you all know, was the plaintiff in Janus versus AFSCME. That case actually is still continuing in the court system. Mark is also now a spokesperson for the Liberty Justice Center, so I want to introduce to you Mark Janus.
Thank you very much, Pat. Thank you all for being here. You know, when I was a state worker over the years, the AFSCME union collected thousands of dollars from me over the course of 10 plus years, and without my consent and without my knowingly providing that consent. And the thing that I'm trying to understand is, if it is illegal as stated by this decision in the Supreme Court, why they took it and why we need it back. And that is the reason we're here, because we think it was illegal. The Supreme Court said it was illegal, and we just want our money back. And that's the very simple part of it. And we just think that myself and Blake, that it's something that is right and should have been done. And thank you very much.
Thank you very much, Mark. And with that, we'll open it up to any of your questions. So that was Mark Janis's case, where we made a similar claim to the claim that we're making today against the very union that used to take money out of Mark's check. Look, we respect Judge Gettleman and Judge Gettleman's opinion. We've appealed that decision to the Seventh Circuit. We've lost in the district court before. We've lost in the Seventh Circuit before. In fact, in Janis, we lost in the district court and in the Seventh Circuit, and ultimately we're successful at the United States Supreme Court. We feel that ultimately the Supreme Court will decide this issue, the issue of the defense that the unions are putting forward. Once a action is deemed to be unconstitutional, it's deemed to have always been unconstitutional. Collecting agency dues from public sector workers is illegal. And that means it was illegal at the time of Janis. That means that it's illegal prior to the time of Janis. And the unions are going to, of course, argue that they have what's called a good faith defense. The Supreme Court has never addressed and upheld that defense. We believe that Judge Alito's opinion addressed some of these issues, where he indicated that the unions since 2012 were aware of the line of cases, Harris versus Quinn, the Rebecca Friedrichs case, then Janis versus AFSCME in 2015, and that the unions took a lot of action in anticipating of what they presumed to be or felt may have been a fait accompli. So we feel very comfortable in our legal arguments, and ultimately we feel the Supreme Court will decide. Yes, ma'am, you had a discussion?
So you just said that this raises a similar issue as what was rejected in Mr. Janis's case, but on the terms of legal arguments, what's different about this case?
So the legal argument will be the same. We're making the same legal argument, and we're appealing the legal argument that was rejected by Judge Gettleman at the district court level. As you know, a district court's judge is not the final say on these issues. We'll appeal that decision to the Seventh Circuit, and then ultimately, if we are successful, we'll see what the unions do. If we're unsuccessful, we'll appeal that decision to the United States Supreme Court and let the justices that decided the Janis decision ultimately decide that case as well.
But would a successful appeal make this lawsuit moot?
No, a successful appeal in that instance would make us be able to apply that case to this case and use it as precedent to recover the money that we feel is owed. Yes? Yes. So that decision and all of the arguments that you just laid out are over. Janis has already decided. No, prior to Janis, they were having money taken against their will. They aren't free riders. Collective bargaining, the court determined, is a political act, and no one should be forced to support a political act. So that decision has already been made. We've moved on from that argument, which failed, and for our opponents, and moved on to the issue that there are, in this instance, millions of dollars, and across this country, hundreds of millions of dollars in fees that the public sector unions collected and kept from agency fee payers prior to the Janis ruling that were illegally and unconstitutionally taken from people across the country. This is our first case in trying to go about the country and do what's right and return money to hardworking people who have been damaged by having money taken from them.
How is this suit different from the suit you lost before Judge Gettleman?
So that decision, the case before is Mark Janis's case. It's one individual plaintiff seeking individual dues. So procedurally it's different because we're attempting, and we feel we'll successfully certify a class of AFSCME fee payers and seek dues on behalf of the class. With respect to the particular legal issue that I feel that you're referring, it's the same legal issue, and we're just going to litigate it again. Yes, correct. That's correct. Because Craig, that's what the Supreme Court law is. Once an activity is deemed to be unconstitutional, it's deemed to have always been unconstitutional. So the actions taken prior to the Janus decision in collecting dues from agency fee payers is unconstitutional. The only issue to be litigated, and what I'm sure our opponents across the country and in this case are going to argue, is that they had a good faith basis to take that money and spend that money, and we disagree that A, they had a good faith basis, and that B, that's a good defense to the claims that we're setting forth.
They have the Supreme Court law on their side at the time.
Yeah, the best way I can put it is that's no longer the case. They don't have the Supreme Court law on their side. The Supreme Court law of the land now is two things. Number one, that you can't take dues from agency fee payers, and that's under Janus, retroactive. It's always been the case now. That's how the law views it. So you can only, so we're filing a case under Civil Rights Act 1983. You can only collect money in the period of time within the statute of limitations for those particular types of cause of action as they would be applied here. So in this case, it's about 14 months worth of time going backwards. In other cases across the country, those statutes of limitations can be 3 years, 4 years, 5 years, 6 years, and we are seeking and have found plaintiffs in places all across the country where we will file similar lawsuits to this one in an attempt to return money wrongfully taken from agency fee payers in the time prior to the Janus ruling. It's too early to tell what the numbers are. In this case in particular, we're seeking a number that we feel will be in excess of $2 million in Illinois.
And it's not lost on some of us that today is May Day and you're filing this on May Day. Is that simply coincidental or is that intentional?
There's no connection between those two things. Coincidental. Anybody else? Thank you very much.